What it does is there's a law, but it'll do it automatically. Yeah, good.
This one's doing.
Press it one more
Let's see if that one works. And you can get maybe a new battery.
It's on, Judge.
All right, ladies and gentlemen, we're here today on multiple cases. The main thing I'm trying to do today is to get a handle on what is going on in this case or these cases. I apologize for the raspiness in my voice. The original case, you have that original file with PM versus, I think it was the very first one was. It was filed in docket number 10600, and it was PM, a minor by her mother and next friend Cheyenne Towery versus AAC Investments LLC. Since that time, we've had motions to intervene been filed, and we've had other lawsuits that have been filed as well. Do you have a specific docket? No.
I do not.
So what I want to do is to address all of as many of the pending motions as we can, try to get some sort of organization about what's going on in this situation. There have been numerous motions to intervene filed, and then those motions have included a proposed order allowing that. And I don't typically do that unless it's very clear that both sides agree, but here is the problem so that everybody understands. You're in Humphreys County, Tennessee. You're not in federal court. You're not in Davidson County. You're in Humphreys County, Tennessee. And Miss Edie, who is our clerk and is one of my favorite people in the whole world, has her and one assistant clerk, deputy clerk in her office and circuit court. And that's it. So when you file something and then you have a proposed pleading that you're asking the court to allow you to file, and then you turn around and say, well, I'd like to mark that file, that becomes very, very difficult for our clerk's office. In addition to that, requesting copies of the file, as has been done in many cases, is virtually impossible for her to comply with that request. In the old days, they had a judge come in every other month. And so Miss Edie had a month off to try to catch up and do what needed to be done. Now she has a judge here every month, and including the general sessions judge. Sometimes she has 2 or 3 judges in a month, and she simply does not have the manpower and the resources to do everything that you might be able to get done in these cases in a larger demographic area. So we're not telling you that we don't want you to do what you need to do to represent your clients. But I'm asking you to consider the fact that we have a limited resources in the clerk's office. We had a meeting this morning with Ms. Danforth, and what she is going to check on is to see if she can give you access to the portal so that you can gain access to all of the filings in these cases, and that'll allow you to print off whatever you want to print off for your own records. Hopefully we can arrange that, and that would simplify things for her as well as you. So I want to give both sides an opportunity to tell me how you want to. I've gone through all of these files, and I have kind of outlined this morning because I've been in other counties, and this is not even my regular day here, but I gave you this day to try to get a handle on this. I've gone through and kind of outlined what I see has happened in this case and what is going on and what is pending, so that I can give you an opportunity to be heard and figure out what we need to do first. So it's not the only big case I've ever handled, but this one's going to be more complicated than most. So anybody that wants to start off, I will give you the floor to start talking.
Thank you, Your Honor. Connor Blair for defendant AAC. We also represent AES. subject of the subpoena in this case, with Ms. John Griffin. It's good to be back before you, Judge. Your Honor is correct that there's been a lot happened since we were last before you. I think there's 7 new defendants.
I thought it was one case, and now I've got about 20.
There was one, now there's 3. There's in cases 10623 and 10624. Opposing counsel, Mr. Ritchie, was unaware that all pending motions were going to be heard this morning, so he is not in the courtroom. So I think in the interest of fairness, we should limit the motions this morning.
All right, which one is that?
It is the Wright and Gillihan cases, 10623 and 10624. So I think here today is counsel for case 10600, which is the Tower case.
All right.
And we appreciate the opportunity to get a handle on everything that's happened. Ms. Stanforth suggested to counsel that this case has tested her gangster. I'm not sure anybody knows what that means, but I think we can all agree that this case should proceed in an orderly fashion and in accordance with the rules as we talked about last time. Your Honor, today there are the unopposed petitions to intervene. We don't oppose those. I think those can be.
Right. So any pending motion to intervene is basically, it makes logical sense to me that if all of these are arising from the same explosion that occurred, some of whom are injured in that explosion, some of whom were the heirs at law of the deceased individuals, then if I understand correctly, everybody's in agreement that any motion to intervene should be granted.
That's correct.
All right. And I will grant those motions to intervene. Now, in any case in which I am granting a motion to intervene, I am going to order that they must file their proposed pleading, not the copy they attach to their motion, but file their actual pleading in the form of a petition, what sets forth their claims, and they have 30 days to do that.
Understood. Thank you. Next, we have the agreed protective order that will govern my client AES's document production. Likewise, everyone that has entered an appearance, as well as plaintiff's counsel, has reviewed that and at least consented to it. I think that can be entered as a matter of course. And I should note for the court that once that is entered, once that protective order is entered, AES is ready to make its document.
All right. And it's an agreed protective order. And I will agree. Have you submitted that order?
Yes, Your Honor. It was submitted, I believe, yesterday by Mr. Pace.
Okay. And will that order basically apply to all cases since we're now here? Let me address one other thing. The motions to intervene are in the original case.
That's correct.
Then we have 2 other cases, and that's the 1063 and 1064, that you're saying that attorney was not able to be here.
Correct.
But it would make sense to me, just in thinking this through, to consolidate all of these cases under one heading, would it not?
Yes, Your Honor.
Without ruling on it because he's not here, but I will.
We haven't moved for that relief, but we had considered doing so. We wanted to get past this initial hearing before doing so. But yes, we don't oppose that.
Well, I mean, all of these arise from the same episode that occurred. Their claims are going to be different, perhaps, and they may have different theories, but it all boils down to the same set of facts. So a consolidation that would allow to streamline the discovery and allow some of this to be done in a more organized fashion, I think, instead of filing. That way it also assists my clerk's office, because instead of filing something under this number and then this number, we're going to be filing under one simple number.
Agreed, Your Honor, and that is convenient for us as well as a defendant.
So we need to check with the lawyer for the other 2 cases and see whether or not he has any opposition to that. If you would assist me in that regard, then if he opposes it, we'll set a hearing date and I'll go forward with that.
I will do that today. As far as the protective order, the agreed protective order governing the entirety of case 10600, I don't want to overstep what I have authority to do. I think that the other defendants want to review that and enter into their own protective
I'm going to
orders.
hand you what I had been given is marked filed on August 27th, what appears to be what you're talking about. Just take a look at that if you will.
That's correct, yes. So this says that protect the confidentiality of the information produced by non-party accurate energetic systems, AES. This protective order will govern AES's document production that's occurring later this week, or right after you enter this. I don't think that the other defendants have agreed that this protective order would govern their document productions.
Well,
So that may
if all I'm going to say is that with this agreed protective order is not signed off on, but the sheet that would have everyone's signature is not apparently attached. Do you have another copy of that? This is one that we received by fax, and the last page has a signature line for me to sign, but it does not have that it was approved by everyone. But we'll take care of that. I'm going to sign the order that's been agreed to for a protective order for AES to produce these documents. Because part of what I did the last time we were here was to allow for discovery, to try to determine what your motion to dismiss. So.
correct. Yeah, and so working in that 60-day window, we worked with plaintiff's counsel to get that protective order agreed to. So that once it's signed, we can produce documents. We of course couldn't produce documents from a federal defense contractor without protection.
Who are the other parties? Is there?
Tanner Gibson here for the plaintiff's local counsel, Hughes Coleman. We'd like an opportunity to be heard on the protective order and a motion we filed late yesterday. I understand it wouldn't be before the court today, but we wanted to bring it to the court's attention. When you're ready. We'll interrupt Mr.
Well, understand this. And those of you who have been before me know this already. I handle 5 counties and I rotate in and out. It is a burden on the clerk here for us to try to shoehorn our hearings into her schedule when she's got other judges in other courts. I am usually able to try to set some days, but I may have to set them in another county. And like, for example, in Dickson, we have 5 courtrooms in the new Justice Center. So one of those is usually designated for me. So what we may have to do is to start setting some of these hearings out of county. If everyone is agreed, you have a right to object if you don't want to have it heard out of county.
No
And every 4 months, I'll be back to hear those motions. Or you can agree to hear it out of county and we'll see how quickly we can get things done. The reason I'm bringing that up is, for example, these other 2 cases, 1063 and 1064, we need to see whether or not there's any opposition to the consolidation and get something on the record about that. I start my term in Dickson County on Tuesday. Actually, I start there Monday, but Tuesday is the actual term. And for that month, I will be there. So if there's something that comes up, we can try to do that. I may take possession of these files, take them to my office, whether I want them or not. And
Start another one. I'm sure there'll be plenty coming.
and that's what I was going to say. You just have to,
Yes, sir.
you just
I'll
have to
just keep going.
coordinate. So,
Yes.
and I interrupted you, but go ahead. So you were talking about this proposed order. I'm ready to sign the proposed order that would be a protection order for the production of documents for the non-party AES. That's in the original one. But then we've got AES as an actual defendant in some of those cases, correct?
In the other 2, okay.
And that's in 1063 and 1064.
That's correct.
Okay.
Next on the docket is our AACs, the defendant in 10600 is our motion to dismiss. We noticed that hearing for October 1st. We since we received the email from the court directing that all pending motions be heard today. We're ready to go forward with that motion if the court would like us to. I think it would, our filing of that motion set off something of a firestorm with other motions. The motion to strike that, motion to dismiss, the notices of deposition, which precipitated motions for protective order to stay those depositions until after the motion to dismiss is heard. We think that a ruling on the motion to dismiss, hearing it today would obviate what we think of the other premature motions. So we defer to the court's discretion on that.
When we were here the last time, I think I had deferred hearing your motion to dismiss until there'd been some discovery of some kind. Is that correct?
You had deferred our motion to dismiss until AES. Well, let me go back. The motion to dismiss and AES's. So there's AAC who owns the land that AES is on, and AES who operated the building that exploded. AAC is the defendant. AES is who plaintiffs subpoenaed for documents. The motion to dismiss AAC is separate and apart from our document production of AES. So the two are going on simultaneously, but they're unrelated. The motion to dismiss AAC deals with the second amended complaint that's been filed and that the other plaintiffs have now joined. The AES document production is for plaintiff's benefit for the rest of the case. It's just third party, non-party discovery.
Well, and if I sign this protective order, then that means that the AES is going to produce the documents that were requested, correct?
That's correct. We have links.
Documents that would be relevant to your motion to dismiss from at least the plaintiff's position. I know you don't think that they're really applicable to your motion to dismiss.
Well, I'm not sure how they could be relevant to the motion to dismiss. Rule 12 contemplates only looking at the second amended complaint. This isn't a motion for summary judgment. It's our position that a motion for summary judgment won't be necessary because the law, the way the allegations are framed, they're pled, and then the lease, which is incorporated, the lease between AAC and AES, which our position is it's incorporated into the second amended complaint. The allegations in the lease give rise to only causes of actions and claims against AAC that necessarily must be dismissed with prejudice. So to the extent that there are documents that plaintiffs want to rely on to oppose our motion to dismiss, it's a bit of an oxymoronic tactic. The AES, it's my understanding that
that's a term I've not heard before. I've heard of oxymoron, but I've never heard of
it doesn't make sense, Your Honor, because you can't oppose a motion to dismiss with record evidence. And I don't think, I haven't been practicing that long, but long enough to know that that's inappropriate. You can't attach deposition testimony to say my complaint should defeat a motion to dismiss. The complaint rises and falls on its own.
I agree with you.
So to the extent that they seek documents from AES, we're fine with that. We actually haven't objected to any of their documents. We're providing documents in response to each and every one of them. That document production is unrelated to our motion to dismiss.
All right. So we have the motion to intervene, the agreed protective order, and your motion to dismiss. Do you have anything else from your perspective that?
Well, if the motion to dismiss is not heard today, or if it's denied, they have moved to strike our motion to dismiss as frivolous, which we oppose, and they have also, in response to our.
Are they saying that your motion is oxymoronic?
Well, they're saying their position is that our motion to dismiss does not accept as true the allegations in it. That's a fine argument. It's a fine argument for the opposition to the motion. It is not grounds to strike the motion.
All right.
In response to our motion to dismiss, they've also noticed the depositions of AAC's corporate representative, as well as one of its two members, John Sunday. Again, our position is that whatever deposition testimony may come from those depositions, it's not appropriate to oppose a motion to dismiss.
All right. So let me hear from the plaintiff in the original case, I guess, and then.
There is one other motion that's pending, Your Honor. It's they've in opposition to our motion for protective order on the depositions. They've moved to compel discovery from AAC. It's our position. AAC is a landlord. They were a passive landlord. There's nothing more to compel from them. To the extent that they want information from one of our clients, they should get it from AES. We agree with them that AES has information that they may find helpful in identifying additional defendants or understanding what happened. Well, like I said, AES is making a fulsome document production later today.
Good morning, Your Honor.
Morning.
I will say that AES was ordered to make a fulsome document production when we were last here in June. They were ordered to do so within 60 days. And not until August 19th did AES attempt to confer on any proposed protective order regarding its document production. So our position is that they've had 2 months. There have been other signs of an attempt to delay and stall in this case, but this is another. We do not oppose the language of the protective order. We would note for the record, though, of course, that AES has not followed the court's order from our early June hearing when it was ordered to produce documents responsive to the subpoena we had already issued. As far as things on the docket and what remains to be decided, AAC filed a motion to dismiss using a couple of arguments, either that they were a passive landlord with no operational control, which is an argument that disputes factual allegations made in our second amended complaint, or their other argument was that it falls under the workers' comp statute and should also be dismissed. And to make, supposedly, I believe, to make that argument in their own motion to dismiss, they attached a list of employees who were present at the facility on the day of the explosion, something that we had asked for in our discovery request to AAC, something that AAC in its responses said they didn't have, couldn't obtain. And then they produced it as a separate outside the pleadings document attached as an exhibit to their own motion to dismiss. AAC accuses plaintiffs of arguing outside the pleadings in our motion to strike when they introduce exhibits and arguments outside the pleading in their own motion to dismiss. Their motion to dismiss requested a hearing date or noticed a hearing date for October 1st. They also filed a suggested briefing schedule. We opposed the briefing schedule and obviously the motion to dismiss because we moved to strike the motion to dismiss for the reasons I just discussed, that it doesn't make much of an attempt at all to comply with Rule 12. Rule 12 says that AAC is to accept the assertions made in the complaint as true. When AAC disputes, and we note in our motion to strike, they at least 60 times in their motion to dismiss dispute factual allegations made in our second amended complaint. So our position is that, you know, we haven't briefed or had an opportunity to brief on the motion to dismiss, but we moved to strike the motion to dismiss. And if the court is of a mind to set a motion to dismiss for hearing, we would understand that. We would obviously like an opportunity to brief it and be heard. But we believe that there's enough based on our motion to strike, our second amended complaint, and their motion to dismiss, which introduces arguments and documents outside the pleadings. We believe there's enough to rule on the motion to strike today. There's also the emergency motion to compel responses from AAC. We were here in early June. AAC and AES were ordered to produce documents within 60 days. In July, AAC responded to our first set of interrogatories, and essentially they said, we're a landlord, we have no responsive documents or information, including when they said that they do not have a list of employees at the facility. So this list of non-responses we were provided in July is insufficient. It's directly contradicted by a document they produced in their own motion to dismiss a month later, And so we believe that further discovery is due and justified as regards AAC. That's the basis of our emergency motion to compel AEC. It's the basis of our motion to compel a deposition of John Sunday, the corporate representative and one of the two members of AAC, also part of AES as well, but we have not noticed his deposition in that capacity. You know, it's part of our lawsuit against AAC, where, you know, the rules of procedure allow us to move the case forward. And that's all we've been trying to do. We've been trying to move the case forward by issuing written discovery requests, now issuing a notice of deposition after we attempted to confer on dates. And the fact that they filed a motion to dismiss in name only, in our mind, does not stay their obligation to participate in discovery of the case. What they actually filed, as I've said before, is a motion to dismiss in name only that introduces documents and pleadings outside of our second amended complaint, doesn't accept the assertions in our second amended complaint as true, and therefore doesn't operate as a motion to dismiss that the court could consider in any decision to stay discovery or stay their obligation to produce a corporate representative for a deposition. So we believe that our motion to compel further responses and a deposition from AAC is ripe for consideration because, as we attached to our motion, we received a list of non-responses. When we know that John Sunday is one of the two members of AAC, we know that AAC is the landlord, the lessor of the property. We know that AAC leased the property for the express purpose of manufacturing and storing explosives. We have reasons to seek discovery from AAC. We have reasons to bring a complaint against AAC, as we alleged in the second amendment complaint. So regardless of what they called their motion to dismiss, because they introduced matters outside the pleadings, we believe it converts it to a motion for summary judgment, while at the same time pointing out their motion to dismiss does, that there are all sorts of factual disputes, genuine disputes in material fact. So we think a motion for summary judgment obviously would need discovery, and we'd like the court to compel them to move forward with discovery. We do agree to the proposed protective order, as Mr. Blair noted. We filed late yesterday because we wanted to get it on the record, because we wanted to put it before the court's attention. We filed a motion yesterday to show cause against AES and AAC because they've had over 60 days from the court's June ruling that they produced documents. They missed that deadline, which passed on August 24th. And only 5 days prior to that did they bring up any suggested proposed protective order. And only now have we agreed on a protective order when documents should have already been produced. That's all I have for now.
Right now, the only motion that I'm hearing is involving the original plaintiffs and the original defendant. That's what, and so I know we have a courtroom full of people that are involved in some of these other matters, and I want to give them an opportunity to be heard, but I want to finish our consideration of what the original case has in there.
Sure. Your Honor, we're arguing, it seems to be several motions at once. Do you have a preference on which one I address first?
Let's move the, well, it doesn't matter to me.
Okay. I suppose just, it's not really a pending motion necessarily, but plaintiff's counsel makes a lot about our document production and how it's a day late or 4 days late, allegedly.
Actually, I think he, if I understood correctly, he said he filed yesterday a show cause motion that I think has to do with the production or lack of production according to him.
Well, it's easily explained by the fact that throughout our meet and confer process, we informed plaintiff's counsel that we were going to be responding to the subpoena on Tuesday, August 25th. There was no objection from plaintiff's counsel. Perhaps we should have memorialized that conversation. I suppose we're to blame for that. But that's exactly what we did. We responded with objections and responses on Tuesday, August 25th. In our opinion, that was timely to the extent there wasn't an agreement and the responses were due August 25th. It's a one-day issue, and we cured it by sending our responses and objections. As to the document production, Your Honor, we represent a federal defense contractor who has highly confidential and confidential documents. Those are the exact documents that plaintiff's counsel has requested. They've requested intra-company text messages. They've requested video footage. They've requested purchase orders, maintenance records, building diagrams, and other information that we can't have floating about without some sort of protective order having been. So as we informed plaintiff's counsel last week or a couple of weeks ago, we can't produce documents until Your Honor enters into a protective order that allows for us to produce those documents as confidential or highly confidential. Plaintiff's counsel understood that. There was no objections. Your Honor, once that order is entered, we have the document production ready to go. We have.
I've signed the order and I'm handing it to the court.
Assuming one of my colleagues is watching this, I think we can have that production out to plaintiffs by lunchtime. So I think that obviates any kind of a show cause issue. You know, we of course didn't ignore Your Honor's 60-day deadline. We operated within the deadline to respond to the subpoena, to get our document production ready, and to work with plaintiff's counsel to enter into an agreement protective. In fact, when we sent over our initial draft protective order, they came back with several edits. In the interest of coming before you this morning without another motion on a protective order, we accepted those edits so that we could get our document production out as soon as possible. We think that we've complied with the court's order, have at least made every attempt to comply with the court's order, and by the end of this morning, we will have fully complied with the order by making the document.
Well, like any other case where there's a dispute over discovery and one side says we're producing the discovery responses, I would be inclined to pass the motion to show cause or motion to compel until plaintiff's counsel has had an opportunity to review what you've produced. And then if there is a continuing dispute about what has been produced or what hasn't been produced, then we'll just have to set that for a specific hearing to determine whether or not they're entitled to the information that you have not disclosed.
Thank you. And one last thing for Your Honor's consideration, it's not just my client's need for a protective order, but TOSHA has several documents that they've given us that we're producing. They also require a protective order. We could not have made a document production until this morning.
Well, I understand. I mean, we enter protective orders for discovery in a lot of cases, including domestic cases where child protective services records are having to be produced. So we've signed that. I have now signed the order and it's been marked filed, so we can move forward from there.
So thank you. Next, like I mentioned earlier, we filed a motion to dismiss. We think it's ready to be heard. If Your Honor wants to exercise his discretion in hearing all pending motions, we think it is one of those pending motions. But I don't want to jump the gun on an argument you don't want for us to make.
Well, your motion to dismiss is against the original plaintiffs in this case, the PM. Is that correct?
That's correct.
So
as well as the intervening plaintiffs, because
they have a motion to dismiss your motion to dismiss.
They do.
Or to strike it, whatever.
And I think I can address that fairly quickly if you'd like me to before we get to the motion to dismiss.
All right.
The motion to strike our motion to dismiss, not only is it just wrong, but it is improper. There are two rules in the Tennessee Rules of Civil Procedure that permit this court to strike a file. One is Rule 12, and the other is Rule 11. Rule 12 contemplates pleadings, which would be a complaint or an answer or a similar filing. This is not a pleading. This is a motion to dismiss. So Rule 11.03 requires that if you're going to move to strike a motion, if another file that's frivolous, you have to comply with a 21-day safe harbor provision, which means, as your honor is aware, they give us the motion. They say, if you don't withdraw or amend or whatever your motion to dismiss, we're going to file this motion to strike seeking fees. Well, they certainly didn't comply with the safe harbor provision. They filed their motion to strike within, I think, a few days of our motion to dismiss. So for that preliminary reason, the motion to strike fails and must be denied. To the extent that the court wants to entertain the merits of the motion,
The merits of which motion?
motion to strike.
Well, I'm not going to grant the motion to strike because I don't, my experience has been that the motion to strike, a motion to dismiss is kind of a redundant situation. And it seems to me that I understand why they might have filed it, but under the circumstances, that goes more to the merits of the motion and the merits of the defense to that motion rather than a separate requirement that this court consider a motion to strike a motion to dismiss. So I am not going to grant that motion to strike. And unless the plaintiff is unready or not ready to argue your motion to dismiss, a Rule 12 motion to dismiss, as you stated, requires that the court look at the facts that are set forth in the complaint and the allegations of the complaint and determine, taking those as true, whether or not that complaint states a cause of action that a trier of fact can consider and rule on. It would only be dismissed if there is no set of facts that the court can find that would be provable under those allegations. And we're talking about the second amended complaint. Is that correct?
That's correct.
Right. So from plaintiff's counsel, is there any reason we can't consider that motion to dismiss at this point? I understand your argument, and you're right. Rule 12 also provides that if the court is asked to consider matters outside of the pleading itself, then it can be converted to a motion for summary judgment. And I understand the plaintiff's argument about that. So is there any reason that you're not prepared to argue the motion to dismiss today?
We've made the argument essentially that we would make in a briefing, but we haven't had the opportunity to brief it. Defendant noticed its motion for October 1st from the time that the court, that your honor and the clerk's office provided notice that all motions or pending issues would be heard.
Well, I think the fair way would be, since it was noticed for October the 1st, let's just leave October the 1st as the hearing date on the motion to dismiss.
Understood.
And I will rule right now that the motion to strike your motion to dismiss is overruled.
Thank you. Related, I want to briefly address Mr. Gibson's assertion and the plaintiff's assertion that we attached documents to our motion to dismiss that are outside the pleadings. The first, we attached for the court's reference a chart of the plaintiffs and intervening plaintiffs who have filed and or are receiving workers' compensation benefits. That is not at all the same thing as a list of individuals who were on the premises at the time of the exposure. Mr. Gibson suggests that these individuals were AAC employees and AAC had the knowledge, that we are withholding that knowledge when it's convenient, but using it when it's helpful to us. That's just simply not true. To ascertain that knowledge, the chart that we attached is not a business record of AACs that we just attached to the motion. It's instead a compilation of information that counsel is able to ascertain and attached solely for the court's ease of reference. We don't even rely on that chart to make our motion. As to the second argument that the lease agreement is outside of the pleadings in this case, Your Honor, the complaint, although it doesn't attach.
Excuse me for interrupting. We are arguing your motion to dismiss.
No, this goes, I'm just rebutting.
Everybody wants to have you don't want, trust me when I tell you that you don't have to rebut something he said by thinking that it's going to carry with me. I'm going to reserve ruling on this. I'm not trying to cut you off. It's something important. But by the same token, what it seemed to me was that you were arguing the merits of your motion to dismiss and the reasons why the defendants or the plaintiffs' response to that motion to dismiss should not be considered. And I think that more properly is to be reserved for that October 1st date.
Understood. Related to the October 1st date, we've moved for entry of a briefing schedule.
Well, we're about to start September. I would say that the obvious, it helps me to have it in a few days. I like to read through everything in the file and read through any of the pleadings before I have to consider it, because I think it gives me an insight to what the parties are arguing.
So, I'm sorry.
No, that's all right.
What we propose is that we file our motion on the day we filed it, that the plaintiffs oppose it or respond to it by September 16th. That gives them a full month to do so. And that, so the court has time.
It gives them a full month.
So we filed on August 17th.
Okay. You were talking about from the
September
date you
16th.
filed.
And then, so that the issues can be fully briefed, AAC's reply deadline would be September 28th, which is 3 days before the
Gibbons, what do you have to say, Mr. Gibson?
If the hearing is set for October 1st, we don't have a problem with that briefing schedule.
Right, we'll adopt the defendant's proposed briefing schedule, and the September 16th is, I think, the date you indicated that Mr. Gibson and the plaintiffs would have to respond to your original briefing, and then you'll have until that 28th to file your response. I'm going to request, normally I don't do this, but I'm going to request that you file your briefs, send them directly to Ms. McKinney, I guess. We want them sent to you so that you can print them for me.
What we can do is when we serve copies on each other, we can BCC the court, whichever way.
Well, what I'm trying to do is to expedite getting them. So file them with the clerk, and then
I know physically we're gonna have a court file, but to keep in accordance with how the court keeps its minutes, I believe it needs to be filed with the
yeah, I'm
court
talking
clerk and
about
then
just a copy to us.
Yes, just send us a copy.
So the original needs to go to the clerk's office and the copy to my office so that I can have it available, so that I can spend my weekend before October the 1st doing nothing but going through this file. So,
We appreciate it.
yeah.
I think the last motion for consideration today is AAC's motion for a protective order against to temporarily stay the depositions of AAC's corporate representative.
Who is the corporate representative?
Well, we haven't
Now,
designated.
you mentioned John Sunday, and
Well, there's only 2 members of AAC. We're entitled to designate anyone who we can prepare. We haven't yet determined who we're going to designate. It may well be John Sunday would be the corporate representative. I can't commit to that.
I think I may have said this at the beginning of this lawsuit. I know I said it in the prior lawsuit that was involved in, I guess, Acura Arms many years ago. I inherited that one as well. I have met John Sunday at a gathering one time. I don't remember what he looks like. I don't remember having anything other than someone introduced him to me, and that was it. If that creates a problem for anybody in this case, speak now or forever hold your peace. I don't know him. I don't socialize with him. I don't have any direct contact with him, but I don't want it coming out later that I had some interaction at a social function one time with him and that somehow makes me prejudiced. So anybody have any problem with it?
Yeah, no objection. To the extent that discovery, AAC has provided written discovery to them in the form of interrogatory responses, requests for admission, and documents. In response to our motion to dismiss, plaintiff's counsel noticed the depositions of AAC and its member Johnson. To the extent that depositions of AAC and Mr. Sunday in his capacity as AAC's member would ever be appropriate, it is certainly not appropriate in the next week. And it is certainly not appropriate for plaintiff's stated purpose of noticing the depositions in case they are required to adhere to the briefing timeline proposed in response to your motion to dismiss. They are certainly not appropriate so that plaintiffs can use that deposition testimony in their opposition to our motion to dismiss. We discussed it earlier, but using record evidence to oppose a motion to dismiss is not just oxymoronic, it's inappropriate. And so to the extent that those depositions need to go forward, it's our position that they won't after the motion to dismiss is heard. But to the extent that they need to go forward, there shouldn't be some grand rush to get it done so that plaintiffs can comply with the briefing schedule. The deposition testimony is unrelated, should be unrelated to their opposition to our motion to dismiss. Plaintiffs have since kind of walked back what their stated need. In response to our motion, plaintiffs counsel emailed us like, we need these depositions so that we can respond to your motion to dismiss. In their opposition to our motion for a protective order, they've said that they need these depositions so that they can identify additional defendants. We are happy for plaintiffs to add additional defendants. We think that's good and perhaps just. The deposition testimonies of AAC and Mr. Sunday in his capacity as a representative of the AAC will not provide that information. The document production from AES, which is a separate corporate entity from AAC, that's where that information is going to come from. The plaintiffs are going to have that today. To the extent any information at all needs to be compelled from AAC, plaintiffs have no real reason to suspect that AAC is withholding information. That goes back to that workers' compensation chart that we attached to our motion. That is nothing more than a compilation of information that we obtained through work products and is simply not the same thing as AAC's knowledge of who was on the premises at the time of the. So for those reasons, because the deposition testimonies would be inappropriate to respond to a motion to dismiss, and because there's simply nothing else to obtain from AAC, we request that the court stay the depositions of AAC's corporate representative and Mr. Sunday until at least after the motion to dismiss is heard. Excuse me, Your Honor. And to the extent that depositions will go forward, we would ask, well, more defendants are being added, as Your Honor knows, there's more defendants are being added to this list. 7 more have been added, several more may be. Mr. Sunday can't be noticed or demanded to give a deposition every time the plaintiffs feel like they want his testimony. He should be deposed, if at all, once. So the court should make plaintiffs' counsel think long and hard about when that opportunity is going to come. We submit that his deposition next week, which is when it's been noticed for, is far premature for his deposition.
Gibson?
Well, I have many things I would like to respond with regarding the motions the court has already decided. I recognize the court's orders on the motion to strike and motion to dismiss, and the protective order, of course, which was agreed to. As regarding our motion to compel responses and a deposition from AAC, our position is that we filed this lawsuit many months ago. We were here in June. The court ordered AAC and AES to provide documents. When AAC responded to interrogatories, they provided 45 pages of documents and a bunch of objections to the interrogatories. We've put that into the court's record with our motion to compel. There's more there. Our complaint alleges that AAC was the landlord and was aware through the earlier explosion that the court's aware of through other means of inherently dangerous activity happening on its property. And then we have the premises liability aspect to our complaint as well, that they had a duty to keep the premises safe. Certainly they had notice of dangerous conditions on the property. I don't understand counsel's argument that the list of employees who've received workers' comp benefits is somehow a throwaway, not to be considered by the court in the motion to dismiss. They chose to attach it as an exhibit to the motion to dismiss. And although, counsel says that it was a compilation of information AAC obtained through the work product, and we're happy to allow AAC to waive its work product protections, but there's more information from AAC that should be produced, that should be provided. We have a statute of limitations deadline of October 10th. And assuming that AAC or any other defendant doesn't name comparatively at fault third parties, we have a need, as the court's aware, to identify at fault parties prior to October 10th. And the fact that AAC has filed a motion to dismiss in name only and now wants to stay this litigation because it filed a motion to dismiss in name only doesn't allow the plaintiffs the opportunity to identify all at fault parties prior to October 10th. We know that John Sunday or Kimberly Sunday or anyone else believing that those are the two members of AAC, we know that AAC has further corporate information. We ask that they provide it and that the court order them to provide it, not necessarily as a means of responding to a motion to dismiss. We recognize that the motion to dismiss should be heard on the pleadings. We also have the need to identify at fault parties prior to the expiration of the statute.
Your Honor, we're certainly not asking the court to stay litigation. We are just asking that things move in an orderly process. There's a complaint filed, then a motion to dismiss that complaint, which is ruled upon, and then if the complaint is not dismissed, then we proceed to discovery. That's the normal course of things, especially in a large case like this one. That's all we're asking. They claim to know that AAC has more information, but we're not providing it. They don't provide any basis except for that they don't like AAC's answers. There's just there's no smoke, there's no fire. The AAC, as the lease agreement that they incorporated into their complaint and that we attached to the motion to dismiss, makes clear that AAC had no rights really to do anything over the premises with AES. It was AES who employed the workers. It was AES who operated the facility. It was AES who worked with the contractors. It was AES who did everything on the premises. AAC simply owned the land.
Who is the owner of AES?
I believe it's Miss Kimberly.
Who?
Kimberly Sunday.
So it's John Sunday that's involved in AAC, and AES is also owned by a member of the family. That's his wife, right?
That's correct. John Sunday is they know because of AAC's responses to their written discovery. John Sunday is not an executive at AES. He's an executive at AAC. He is an employee. He's not an executive. So they claim to know that AAC is withholding information, but they don't say how. It's just it's an empty suspicion. We've complied with the discovery, the written discovery, the depositions of the corporate representative, and certainly John Sunday won't shed any more light on potential additional defendants. That information, to the extent it exists, will be in AES's document production, which they'll get later today.
Just briefly, Your Honor.
It's not necessary. I'm not going to stay the deposition simply because I think the most compelling argument that Mr. Gibson has made is that you've got a statute of limitations that's rapidly approaching, and the plaintiffs have a right to take these depositions under the normal course. Yes, there is a motion to dismiss down, but whether the motion to dismiss will deal on the merits of the actual complaint rather than any additional evidence, unless there's some reason that that would change. And it does appear to me that because of the context, so to speak, in that AES is owned and operated by a member of the Sunday family, and then John Sunday is someone who may have knowledge. The plaintiff may desire to depose both John and Kimberly Sunday regarding. I think it's important to allow the depositions to take place for the purpose of identifying whether or not the defendants, if the motion to dismiss is not granted, are going to blame any other parties. If there's going to be an opportunity to say that there are additional defendants that weren't joined, then that needs to be done before the statute of limitations. And as a result of that, I think that it's imperative to allow the plaintiff to proceed as normally done in a civil case, to depose the parties and to determine whether or not there are additional defendants that need to be brought in. There are quite a few that have been added while this case has been pending. My understanding is that we've added Boiler Supply Company Incorporated, Lee Industries, Uline Incorporated, Emerson Electric, Cleaver Brothers Company, Ajax Boilers Incorporated, and Ace Heaters. There may be others that I didn't mention, but so there are a number of defendants who have been added by either the intervenors or these additional two cases that we're now likely to consolidate. Mr. Sunday being deposed in the original case before that motion for dismissal is heard is just a necessary part that this court finds would be in fairness to the plaintiffs in this case, to allow them to ensure that there's no sudden discovery after the statute of limitations runs of some other persons that might need to be added as well. So I'm going to deny the motion for a protective order to stay the depositions and allow that to go forward, and then we'll hear the motion to dismiss, which will be on the merits of the complaint, as I've stated, on that October 1st date. Is there anything else then in this original motion, in this original case?
Yes, Your Honor. We of course accept the court's ruling. I just would like
Thank you.
a couple of clarifications. Because I'm in court next week. They've noticed the depositions for September 3rd and September 4th.
Before you leave today, we'll find the date. You need to just sit down with each other's calendar and get it done. It needs to be done before that October 1st date.
And that's what I was going to ask for. Was
I understand you're a busy lawyer and you need to have this done on a schedule that you can adhere to. So.
The other point of clarification is that if plaintiffs are deposing Mr. Sunday and AAC for the purpose of identifying additional defendants, is it Your Honor's position that the scope of those depositions will be limited to those topics? And if not, I would request that if this is going to be a full deposition of all the issues in this case, that this would be the one time the plaintiffs get to depose Mr. Sunday.
Mr. Gibson, there's logic in what he says, because obviously your purpose in seeking the deposition before the expiration of the statute of limitations is to identify any other defendants. And I understand you're also wanting to get additional information. But we now have all of these other plaintiffs who are intervening or filed separate lawsuits, all of which have named Mr. Sunday and some of which have named Kimberly Sunday as defendants, along with, I thought it was interesting, John Doe's 1 through 50. In any event, my point of that is, if I allow you to go into a full-fledged deposition of Mr. Sunday and the corporate representative of AAC, then I'm simply allowing yours to be done, and then every other plaintiff in this case would have the right to depose those parties as well, because they're defendants in their cases. So I think that I'm allowing, and I am going to restrict the deposition of Mr. Sunday or the corporate representative of AAC to the identification of any additional defendants that might be properly brought before the court for responsibility for the explosion which occurred. Well, by doing that, it allows you to preserve your right to bring in additional defendants before the statute runs. but it also avoids repetitive depositions of Mr. Sunday and the corporate representative by other plaintiffs numerous times. And the purpose of consolidating these cases and allowing the intervention is to streamline, hopefully, the discovery. And that is where we have depositions of where all of the lawyers who are representing the various plaintiffs and defendants are able to participate in one discovery process rather than multiple depositions. And hopefully that would be the case. So I want to give you the opportunity to get your information before the statute runs, but I think we need to limit it to that.
Understood, Your Honor. Just, I want to make it clear that our deposition for that purpose will necessarily require more than just the question, who else is at fault? Well,
So I don't expect you to go into the deposition and simply ask two questions. You know, I want you to have, but as far as a far-reaching, deposition, that I don't want to have the entirety of this case litigated in that deposition when we're going to have to redo that all over again with the other plaintiff's lawyers. Does that answer your question?
Yes, sir.
All right. That needs to be in this order that's being drawn as well. So.
Yes, sir.
Anything else for the original case?
No.
All right. So let's see if there's anyone else here from any of the other litigation that need to be heard on anything.
Counsel in cases 1063 and 1064 is not here. He told me I have authority to act on his behalf, Mr. Ritchie. The only motion, aside from the motions to dismiss that is pending, is the motion for an entry of a briefing schedule. It's not opposed. We would request the court to enter the same briefing schedule in those cases that it entered in this in 1064.
Right. He's aware that that's September the 16th.
Yes, sir.
All right, then we'll enter an order the briefing schedule for 1063 and 1064 that is identical to the briefing schedule in the original case.
Thank you.
Anybody out in the courtroom that has any of the other lawyers involved in any of this other litigation that have anything that you need to hear?
If I may, Your Honor.
Come on up.
Yes. Lindsay Cordes for the plaintiffs that are intervening. Hubert Harness and Angela Van Skyok. This is just a minor housekeeping matter, Your Honor. We had a proposed agreed order deeming the complaints filed for these intervening plaintiffs. So this is just a minor housekeeping matter.
That was the order that you gave me. They'll do their own complaint and file.
What you may have heard me make sure that I'm clear. If I have granting the motion to intervene, which I am doing, then you need to go ahead and file separately, not an order deeming what you filed to be filed, but I want you to file the original complaint of whatever it is you're asking separately so that we have a file date as of that date.
Okay, thank you, Your Honor.
As well as the appropriate filing fees
Yeah.
for filing.
That's the other thing.
complaints with
Anybody who
the
is intervening is still held to the filing fees. So, all right.
Thank you.
Good morning, Your Honor.
Good morning.
Russell Lewis from the Nashville Bar. I'm also representing one of the intervening plaintiffs.
All right.
We previously submitted a proposed agreed order as well. And I understand what Your Honor just directed us to do. Would you like us to resubmit
Yes.
the order for allowing intervention?
Anyone who has filed a motion with a proposed order needs to submit an order granting that intervention and file your proposed pleading that you want to do separately, along with the litigation fees that Ms. Edie can give you.
And just to be clear, what we had submitted previously was titled proposed agreed order. So we will submit a clean agreed order.
Correct.
Thank you, Your Honor.
All right.
One final issue, Your Honor, being that yesterday we filed the supplemental motion to
Come on up to
compel.
the microphone because we're recording all of this. I want to make sure everything gets on the record. We don't have a
Only
court
because
reporter
yesterday
here
we
today.
filed Yesterday we filed the supplemental motion to compel or show cause against AES because they had not met the 60-day requirement to produce documents. I'd ask that for the purposes of the order memorializing what occurs today, that be deemed stayed or not yet, right?
I'm just going to pass that motion
Okay.
to compel or show cause to allow you to review the information if there is additional information that you feel like they have not been forthcoming on or whatever, then you need to file notice that you'd like to be heard again about that, and then we'll try to find a day to get you heard before the October 1st date if necessary.
Okay, understood. And yesterday, I believe we had new summonses issued for 4 defendants. Is that right, Ms. Stinson?
There was about 8.
So that's all we need. So we need no court intervention on that.
No,
Thank you, y'all.
Anybody else? It's your opportunity while I'm here. Right, I will be in Dickson County starting actually Monday for the entire month of September. So anything that comes up in this case, if you will contact my office, if there's an urgency that needs to be addressed, I will find some time. You may be at the end of a Chancery docket where I'm hearing divorce cases and you can sit through. I might do that. If you have something that's going to have to be heard, I might make you sit through a couple of contested divorces to let you know how lucky you are.
Powerful disincentive.
This is a tragedy that occurred. I want everybody to understand that. And Humphreys County has had more than their fair share of tragedies with the flood that occurred and now this explosion. I've been coming over here since I was a high school student, having to come to my dentist here in Dr. Powers in Humphreys County. So this county holds a special place in my heart. I don't take lightly my obligation to treat everybody involved in this case, including the defendants, fairly. And I will do the very best I can to keep this case on track and to organize it and to give you the benefit of my rulings. And I only ask that you cooperate and try to keep it as organized as possible. And if there's an issue, contact us and we'll set a hearing. I would like to see that the lawyers, and I think you're all good lawyers. I certainly have had the defense lawyers and the plaintiff's lawyers here before, but I was a lawyer for 37 years and I practiced every kind of law there was. One of the things that I have as I admire are people who can set aside personal problems to conduct themselves in a litigation like this with appropriate decorum. And I think you have done that to this point. So I would just ask you to try to continue to do that. This is going to be a mess. It already is a mess. And we're going to sort it out. Y'all remember, you don't, you're all too young. When I first started practicing here, we had the Murray County jail fire. Y'all remember any of some of the older lawyers now? Yeah. And that was a case where the jail in Murray County, Tennessee, or Maury County, however you want to pronounce it, caught fire. And there were people trapped behind locked cells, and they perished in horrible, horrible ways. Well, imagine that there were multiple, I don't remember how many and who may have, but there were a lot of people who died in that, and there were a lot of plaintiffs, and I sat in on depositions that were held in the high school auditorium, if I recall correctly, because of the number of plaintiffs. I was sitting in for my senior lawyer, Alan Kearns, and that's what I foresee is probably going to happen in your situation. Whenever you get to these depositions, assuming that it continues, and I don't grant the motion to dismiss, you're looking at finding venues that will allow for depositions to be taken with multiple plaintiffs' lawyers and defense lawyers and so forth. So we're going to, because we've got now, 7 additional defendants, all of whom are going to have lawyers. So this thing is exploding exponentially before our very eyes. So let's try to make sure that we all try to stay on the same. My only thing in saying all of this is it's going to be difficult to keep it organized. I have her back. So anything happens, you can trust that I'm going to support Edie Stainforth and what she needs to do. So if you have a problem, you can contact me. I'm the one where the chip falls to at the end. So, all right, I think that concludes our business for today. Unless somebody has something else, we will then stand adjourned.
All rise.
and I'm going to try to see if there's a way for me